In the evolving landscape of privacy, understanding the U.S. privacy environment is crucial for professionals navigating legal, regulatory, and ethical considerations. The U.S. legal framework, with its unique blend of federal and state laws, regulatory guidelines, and common law principles, forms a complex tapestry that governs the collection, use, and protection of personal information. This essay explores the structure of U.S. law as it pertains to privacy, examining the roles of government branches, the sources of law, and their impact on privacy protections. Branches of government. The U.S. Constitution establishes 3 branches of government: legislative, executive, and judicial, each with distinct roles and responsibilities in the legal system, ensuring a balance of power that includes checks and balances. Legislative branch. Comprising the Senate and the House of Representatives, Congress has the power to enact laws that impact privacy, such as the Health Insurance Portability and Accountability Act, HIPAA, and the Children's Online Privacy Protection Act, COPPA. These laws lay the foundation for privacy rights and protections across various sectors. Executive branch, led by the President and including administrative agencies, this branch enforces the laws. Agencies like the Federal Trade Commission, FTC, and the Department of Health and Human Services, HHS, play pivotal roles in regulating and enforcing privacy standards, issuing regulations that detail how privacy laws are implemented and complied with. Judicial branch. Courts interpret laws and adjudicate disputes. Through landmark decisions, the judiciary has significantly influenced privacy norms and expectations. Cases such as Katz v. United States and Carpenter v. United States have reshaped the understanding of privacy in the context of technological advancements and societal changes. Sources of law. The multifaceted U.S. legal system draws from various sources, each contributing to the overarching privacy framework. Constitutions. The U.S. Constitution, along with state constitutions, provides the bedrock of legal rights and protections, including privacy. Although the Constitution does not explicitly mention privacy, amendments such as the 4th, protection against unreasonable searches and seizures, and the 14th, due process and equal protection clauses, have been interpreted to protect privacy rights. Legislation. Federal and state legislatures enact statutes addressing specific aspects of privacy. For instance, federal laws set nationwide standards, while state laws like the California Consumer Privacy Act, CCPA, offer additional protections and rights at the state level. Regulations and rules. Administrative agencies fill in legislative gaps through regulations and rules, offering detailed guidance on law implementation. The FTC's privacy rule, for example, specifies how certain businesses must protect consumer information. Case law. Judicial decisions interpret laws and set precedents that influence future privacy protections and interpretations. The evolving nature of privacy is often reflected in case law, adapting legal principles to contemporary issues and technologies. Common law. Arising from judicial decisions, common law principles, including torts related to privacy violations, supplement statutory protections. These principles evolve through judicial interpretation, adapting to new challenges and societal norms. Contract law. In the digital age, privacy is often governed through contractual agreements, such as terms of service and privacy policies. These agreements outline the rights and obligations of parties regarding data privacy and protection, playing a crucial role in the privacy landscape. Conclusion. The U.S. privacy environment, characterized by its complex legal framework and dynamic nature, demands a thorough understanding of the interplay between different branches of government and sources of law. As privacy continues to emerge as a critical issue in the digital age, the roles of legislation, regulation, and judicial interpretation become increasingly significant. For privacy professionals, navigating this landscape requires not only knowledge of existing laws and regulations, but also an understanding of the principles and precedents that shape privacy, rights, and protections in the United States. The landscape of privacy law in the United States is a complex patchwork of federal and state regulations, sector-specific rules, and evolving interpretations. At the heart of navigating this landscape are key legal definitions that shape the applicability, enforcement, and implications of privacy laws. This essay delves into 4 foundational legal definitions: jurisdiction, person, preemption, and private right of action. Understanding these terms is crucial for grasping how privacy laws operate and affect individuals, businesses, and government entities within the U.S. Jurisdiction. Jurisdiction refers to the authority of a court or other legal body to hear and decide cases. In the context of U.S. privacy laws, jurisdiction determines which courts have the power to hear disputes or enforce regulations based on geographical boundaries, the nature of the legal issues, or the parties involved. For example, state privacy laws apply only within the specific state's borders, but federal privacy laws can span the entire country. Jurisdictional issues can become complex in cases involving online activities, where data crosses state and national boundaries, challenging traditional notions of jurisdiction. Person. The legal definition of a person can vary significantly across different privacy statutes, ranging from natural persons, individuals, to entities such as corporations, partnerships, and other organizations. The definition determines who has rights under the law, who is obligated to comply with its provisions, and who can be held liable for violations. For instance, certain privacy laws may protect only individuals' personal information, while others extend protections to data related to business entities. Preemption. Preemption is a legal doctrine that occurs when a higher authority's laws take precedence over the laws of a lower authority when both could apply. In the U.S. privacy context, federal preemption can make a federal privacy law supersede state laws, creating a uniform national standard. However, many U.S. privacy laws contain floor preemption, meaning federal law sets a minimum standard of protection, but states are free to enact more stringent laws. The dynamic between federal and state laws is a critical consideration for compliance strategies, especially for businesses operating across multiple states. Private right of action. A private right of action allows individuals to sue for violations of a law rather than relying solely on government enforcement. This legal definition is pivotal in the realm of privacy, as it directly impacts the enforcement landscape and individuals' ability to seek redress. Some U.S. privacy laws, like the California Consumer Privacy Act, CCPA, grant a limited private right of action for certain violations, such as unauthorized data breaches. This mechanism can significantly influence organizations' privacy practices by increasing the potential for litigation and the associated financial and reputational risks. Conclusion: the legal definitions of jurisdiction, person, preemption, and private right of action are foundational to understanding and navigating the U.S. privacy environment. They influence the scope, applicability, and enforcement of privacy laws, impacting all stakeholders involved. As the digital economy continues to evolve and new privacy challenges emerge, these legal definitions will play a crucial role in shaping the future landscape of privacy protection in the United States. The United States privacy landscape is a complex web of regulations and oversight mechanisms designed to protect personal information and ensure data privacy across various sectors. Unlike many countries that have a single, comprehensive data protection law, the U.S. approach to privacy is sector-specific, relying on a patchwork of federal and state regulations overseen by multiple regulatory authorities. This essay provides an overview of the key regulatory authorities in the U.S. privacy environment, including their roles and responsibilities. Federal Trade Commission, FTC. The FTC is perhaps the most influential player in the U.S. privacy regime. It acts under the FTC Act, which prohibits unfair or deceptive practices in the marketplace. The FTC has used this authority to address a wide range of privacy issues, from data security practices to the enforcement of privacy promises made to consumers. The agency's actions include investigating privacy violations, taking enforcement actions against companies, and providing guidance and policy recommendations on privacy and data security issues. Federal Communications Commission, FCC. The FCC regulates interstate and international communications by radio, television, wire, satellite, and cable in all 50 states, the District of Columbia, and U.S. territories. Its role in privacy is primarily through the oversight of the telecommunications and broadband industries. The FCC enforces privacy protections for customers of broadband and other telecommunication services, such as the rules requiring customer consent for the use and sharing of sensitive personal information. Department of Commerce, DOC. The DOC plays a significant role in privacy through its Internet Policy Task Force, which works on privacy policy issues, and the National Telecommunications and Information Administration, NTIA, which advises on telecommunications and information policy. The DOCI has been instrumental in developing privacy frameworks, such as the Privacy Shield framework for transatlantic data flows, now invalidated and under review for a new framework, and engaging in international privacy discussions. Department of Health and Human Services, HHS. HHS oversees the protection of health information through the Health Insurance Portability and Accountability Act, HIPAA. HIPAA sets national standards for the protection of individually identifiable health information by health plans, healthcare clearinghouses, and certain healthcare providers. HHS's Office for Civil Rights enforces HIPAA's privacy and security rules. Banking regulators. Banking regulators oversee the financial sector's privacy practices, focusing on the protection of customer information. Federal Reserve Board regulates banks under its jurisdiction to ensure they comply with privacy laws and regulations, including the Gramm-Leach-Bliley Act, GLBA, which requires financial institutions to protect the confidentiality and integrity of consumer financial information. Comptroller of the Currency oversees national banks and federal savings associations, ensuring they meet the privacy and data protection requirements set forth in GLBA and other relevant regulations. State Attorneys General. State Attorneys General play a critical role in enforcing state-level privacy laws and regulations. They have the authority to bring civil or criminal actions against companies for violating state privacy laws, such as the California Consumer Privacy Act, CCPA. State Attorneys General often act as the frontline defenders of consumer privacy rights at the state level. Self-regulatory programs and trust marks. Beyond governmental regulators, the U.S. privacy environment includes various self-regulatory programs and trust marks that provide mechanisms for privacy protection and compliance. These programs, often industry-led, establish privacy standards and practices for members to follow, offering a way for companies to demonstrate their commitment to privacy through certification and compliance with these standards. Examples include the Digital Advertising Alliance, DAA, and the Network Advertising Initiative, NAI, which set forth principles for online privacy and targeted advertising. The U.S. privacy environment, with its multiple regulatory authorities and a mix of federal and state oversight, reflects the complexity and diversity of the digital age. Each authority plays a crucial role in shaping the privacy landscape, enforcing regulations, and guiding organizations in responsible data management practices. As technology and data use continue to evolve, the interplay among these regulatory bodies will be vital in addressing new privacy challenges and protecting consumer rights in the digital realm. The U.S. privacy environment is a complex tapestry woven from various federal and state laws, each designed to protect personal information in different contexts. Unlike some jurisdictions with a single, comprehensive data protection law, the United States approaches privacy through a sector-specific lens, creating a patchwork of regulations that can be challenging to navigate. This video explores the key aspects of understanding U.S. privacy laws, including their scope and application, methods for analyzing a specific law, determining jurisdiction, and the concept of preemption. Scope and application. U.S. privacy laws are characterized by their specificity and targeted application. They often focus on particular industries, types of data, or activities. For example, the Health Insurance Portability and Accountability Act, HIPAA, protects health information, while the Children's Online Privacy Protection Act, COPPA, safeguards children's online data. Understanding a law's scope involves identifying the entities it regulates, e.g., healthcare providers, financial institutions, educational institutions, the types of data protected, e.g., personal health information, financial data, student records, and the activities it covers, e.g., data collection, processing, sharing. Analyzing a law. When analyzing a privacy law, it's crucial to dissect its requirements, exceptions, and enforcement mechanisms. This involves a detailed review of the law's text, including definitions of key terms, obligations for data controllers and processors, rights granted to individuals, and the conditions under which data may be collected, used, and disclosed. For instance, understanding HIPAA requires familiarity with concepts like protected health information, PHI, covered entities and business associates, as well as the privacy and security rules that outline specific compliance obligations. Determining jurisdiction. Jurisdiction plays a critical role in the U.S. privacy landscape. Many U.S. privacy laws have state-specific counterparts that may offer additional protections or requirements. For example, the California Consumer Privacy Act, CCPA, and the Virginia Consumer Data Protection Act, VCDPA, provide residents of those states with specific rights regarding their personal information. Determining jurisdiction involves examining both the location of the data subject and the location of the entity handling the data. It's also important to consider the extraterritorial reach of certain laws, which may apply to entities outside the jurisdiction if they process the data of residents within the jurisdiction. Preemption. Preemption is a legal doctrine that arises when a higher authority's laws supersede those of a lower authority. In the context of U.S. privacy laws, federal laws may preempt state laws if there is a conflict, rendering the state laws inapplicable. However, many federal privacy laws explicitly allow for more stringent state laws to coexist, creating a situation where businesses must comply with both federal and state regulations. Understanding preemption is crucial for assessing how different layers of privacy laws interact and which standards apply in a given situation. Conclusion: navigating the U.S. privacy environment requires a nuanced understanding of the scope and application of various laws, the ability to analyze specific regulations, knowledge of jurisdictional issues, and an awareness of how preemption can affect the applicability of laws. As the digital economy continues to evolve and new privacy challenges emerge, staying informed about these aspects of U.S. privacy law is essential for organizations seeking to comply with their legal obligations and protect the privacy of individuals. In the digital age, managing information within the intricate landscape of U.S. privacy laws requires a multifaceted approach. This video delves into various aspects of information management from a U.S. perspective, covering data sharing and transfers, privacy program development, user preferences, incident responses, workforce training, accountability measures, data retention and disposal, online privacy considerations, vendor management, international data transfers, and the resolution of multinational compliance conflicts. Data inventory, classification, and flow mapping. A foundational step in managing data privacy is conducting a thorough data inventory to identify what data is held, followed by classifying this data based on sensitivity and regulatory requirements. Data flow mapping then visualizes how data moves within and outside the organization, highlighting potential privacy risks during transfers. Privacy program development. Developing a robust privacy program involves setting up policies and procedures that ensure compliance with applicable laws and standards, including the management of data throughout its life cycle, from collection to disposal. Managing user preferences. Respecting and managing user preferences regarding their data is crucial. This involves giving users control over their data, including the ability to opt in or opt out of data processing activities, in compliance with regulations like the California Consumer Privacy Act, CCPA. Incident response programs. Organizations must establish incident response programs to address cyber threats such as ransomware. These programs should include procedures for identification, containment, eradication, and recovery, alongside communication strategies for stakeholders. Workforce training. Educating the workforce on privacy policies, data protection, best practices, and specific roles in maintaining privacy is essential for fostering a culture of privacy across the organization. Accountability. Accountability mechanisms, such as audits and assessments, ensure that privacy practices meet stated policies and legal requirements. This also involves documenting processes and decisions related to privacy management, data and records retention and disposal. Under laws such as the Fair and Accurate Credit Transactions Act, FACTA, organizations are required to securely dispose of data and records no longer needed, minimizing the risk of privacy breaches. Online privacy. Privacy notices. Online privacy practices must be transparent, necessitating clear and accessible privacy notices that inform users about data collection, usage, and sharing practices. Vendor management. handling vendor incidents, cloud issues, and third-party data sharing. Effective vendor management involves due diligence and monitoring of vendors' privacy practices, particularly in handling incidents, managing data in the cloud, and ensuring the privacy of shared data. International data transfers. Mechanisms for compliance. International data transfers are governed by mechanisms such as the EU-US Data Privacy Framework, binding corporate rules, BCRs, standard contractual clauses, SCCs, and others, ensuring that data transferred internationally meets US privacy standards. Schrems decisions. The Schrems decisions have significant implications for data transfers, challenging the adequacy of certain transfer mechanisms and necessitating ongoing vigilance and adaptation by organizations. Other key considerations: GDPR requirements and APEC privacy framework. US-based global multinationals must navigate not only US privacy laws, but also international requirements like the GDPR and the APEC privacy framework, ensuring comprehensive compliance. Resolving multinational compliance conflicts. Organizations often face challenges in reconciling requirements across jurisdictions, such as GDPR data protection versus US e-discovery demands. Navigating these conflicts requires a balanced approach that respects privacy while complying with legal obligations. In conclusion, the US privacy environment demands a dynamic and comprehensive approach to information management, requiring organizations to stay informed and agile in their privacy practices to navigate the complex landscape of domestic and international data protection regulations. The enforcement landscape of US privacy and security laws is complex and multifaceted, involving various mechanisms and entities, from criminal and civil liability to self-regulatory enforcement. This video essay explores the diverse facets of enforcement, elucidating how they collectively contribute to the protection of privacy and security in the United States. Criminal versus civil liability. In the context of privacy and security laws, enforcement can either take a criminal or civil liability form. Criminal liability involves the government prosecuting violations that entail illegal activities, such as unauthorized access to systems, hacking, or identity theft, leading potentially to imprisonment or fines for the individuals involved. Civil liability, on the other hand, allows individuals or entities to seek redress for breaches that affect them, often resulting in monetary damages or orders for corrective actions. General theories of legal liability. The enforcement of privacy laws in the US is grounded in several legal theories, each providing a basis for liability and redress. Contract. Breach of contract claims arise when one party fails to honor the privacy protections promised in a contract, such as terms of service or privacy policies. Tort. Privacy violations may constitute torts, such as invasion of privacy or negligence, allowing affected individuals to seek damages for harm suffered. Civil enforcement. Regulatory bodies like the Federal Trade Commission, FTC, enforce privacy laws through civil actions, imposing penalties and requiring corrective measures for non-compliance. Negligence. Negligence plays a significant role in privacy law enforcement, particularly when an entity fails to take reasonable measures to protect personal information, leading to unauthorized access or breaches. Entities may be held liable for damages resulting from such negligence. Unfair and deceptive trade practices, UDTP. The FTC uses UDTP laws to pursue companies that fail to protect consumer privacy or mislead consumers about their privacy practices. This enforcement mechanism is crucial in holding companies accountable for their privacy promises and practices. Federal enforcement actions. At the federal level, various agencies, including the FTC, the Department of Health and Human Services, HHS, and the Securities and Exchange Commission, SEC, play pivotal roles in enforcing privacy and security laws. Their actions can include investigations, settlements, and litigation to enforce compliance and protect consumer privacy. State enforcement. State attorneys general, AGs, and specific regulatory bodies like the California Privacy Protection Agency, CPPA, are increasingly active in privacy law enforcement. They can initiate investigations, bring lawsuits, and negotiate settlements, often leading the charge in addressing privacy violations affecting their constituents. Cross-border enforcement issues. With the proliferation of digital data flows across borders, entities must navigate complex international privacy regulations. The Global Privacy Enforcement Network, GPN, facilitates cooperation and information sharing among privacy enforcement authorities worldwide, helping to address cross-border privacy concerns. Self-regulatory enforcement. Self-regulatory frameworks, such as the Payment Card Industry Data Security Standard, PCI DSS, and various trust marks, play a complementary role in privacy enforcement. These frameworks set industry-specific standards and provide mechanisms for certification and compliance verification, enhancing privacy protections through market-driven incentives. The enforcement of U.S. privacy and security laws is characterized by its layered and diverse approach, incorporating both public and private mechanisms. This multifaceted enforcement landscape ensures that privacy protections are adaptable and robust, capable of addressing the evolving challenges of the digital age. Other key considerations for US-based global multinational companies. GDPR requirements. The General Data Protection Regulation, GDPR, sets a high standard for data protection and affects US-based companies processing the data of individuals in the EU. Compliance requires a comprehensive approach to data protection, including rights for individuals, data protection impact assessments, and strict data processing principles. APEC Privacy Framework. The Asia-Pacific Economic Cooperation, APEC Privacy Framework, provides guidelines for ensuring privacy and data protection across the Asia-Pacific region. US-based companies operating in this area must navigate these principles alongside other regional and national regulations, resolving multinational compliance conflicts. EU data protection versus e-discovery. Reconciling EU data protection requirements with US legal obligations for e-discovery presents a challenge for multinational companies. Balancing the need for data access in legal proceedings with the protection of personal data requires careful negotiation and adherence to legal frameworks that facilitate such transfers. Conclusion: navigating the US privacy environment requires a sophisticated understanding of both domestic and international data protection landscapes. As digital technologies continue to evolve, so too do the challenges and opportunities for privacy management. By adopting comprehensive privacy programs, fostering a culture of accountability, and remaining vigilant in the face of cyber threats and regulatory changes, organizations can not only comply with legal requirements, but also build trust with customers and stakeholders. The intersection of legal compliance, technological innovation, and ethical considerations in the management of information underscores the importance of a proactive and strategic approach to privacy in the digital age. The digital age has ushered in unprecedented access to information, creating vast opportunities for economic growth, innovation, and social interaction. However, this evolution has also posed significant challenges to individual privacy. In the United States, the private sector's collection and use of data are subject to a complex framework of laws and regulations, with the Federal Trade Commission, FTC, playing a central role. This essay explores the limits on private sector data collection and use, focusing on cross-sector FTC privacy protection, including the Federal Trade Commission Act, FTC Privacy and Security Enforcement Actions, the Children's Online Privacy Protection Act of 1998, COPPA, and considerations for the future of federal enforcement in areas such as data brokers, big data, the Internet of Things, IoT, artificial intelligence, AI, and unregulated data. The Federal Trade Commission Act. The Federal Trade Commission Act, FTCA, enacted in 1914, serves as the cornerstone of privacy and consumer protection in the United States. Although not explicitly focused on privacy, Section 5 of the FTCA prohibits unfair or deceptive acts or practices in or affecting commerce. This broad mandate has allowed the FTC to adapt its enforcement to address privacy violations and data security breaches that can harm consumers. The adaptability of the FTCA is crucial in the digital era, where new technologies and business models emerge rapidly. The FTC uses its authority under the FTCA to investigate and take action against companies that fail to protect consumer privacy or that mislead consumers about their privacy practices. These actions are not limited to specific sectors, allowing the FTC to address privacy concerns across the economy. FTC privacy enforcement actions. The FTC has brought numerous enforcement actions against companies for violating consumers' privacy rights. These actions typically address situations where companies have made false or misleading statements about their privacy practices, or have failed to maintain reasonable security measures to protect sensitive consumer information. For example, the FTC settled with Facebook in 2012 for making deceptive privacy assurances to users. More recently, in 2019, the FTC finalized a record $5 billion settlement with Facebook for privacy violations, highlighting the FTC's commitment to enforcing privacy protections. FTC security enforcement actions. In addition to privacy enforcement, the FTC has actively pursued companies for failing to adequately protect consumer data, thereby putting consumers at risk of identity theft and other harms. The FTC's approach to data security emphasizes the need for companies to implement reasonable and appropriate measures to protect consumer data based on the sensitivity of the data and the size and complexity of the company's operations. Wyndham Worldwide Corporation's case exemplifies the FTC's security enforcement actions. The FTC alleged that Wyndham's failure to maintain reasonable data security measures led to 3 data breaches in less than 2 years, affecting hundreds of thousands of consumers. The case, which was settled in 2015, underscored the importance of data security as a critical component of consumer protection. The Children's Online Privacy Protection Act of 1998, COPPA. COPPA represents a specific statutory framework aimed at protecting children's privacy online. The Act requires operators of websites and online services directed to children under 13 and those who knowingly collect personal information from children to obtain parental consent before collecting, using, or disclosing such information. The FTC enforces COPPA and has issued rules detailing the requirements for compliance. Enforcement actions under COPPA have targeted various companies, from toy manufacturers to social media platforms, for failing to comply with the Act's provisions. These actions demonstrate the FTC's commitment to protecting children's privacy in the digital environment. Future of federal enforcement. Looking ahead, the FTC faces challenges in addressing emerging privacy issues related to data brokers, big data, IoT, AI, and unregulated data. These areas present new risks to consumer privacy and require innovative regulatory approaches. Data brokers, which collect and sell personal information, often operate in the shadows of the digital economy. The FTC has called for greater transparency and accountability for data brokers, but comprehensive regulation remains elusive. Similarly, the proliferation of big data analytics, IoT devices, and AI technologies raises complex privacy concerns. These technologies can collect vast amounts of personal information, often without explicit consent or awareness. The FTC must navigate these challenges, advocating for privacy protections that keep pace with technological advancements. The future of federal enforcement may also involve new legislation to address gaps in the current privacy framework. The debate over a federal privacy law continues, with proponents arguing for comprehensive legislation to provide clear and consistent privacy protections for consumers. Such legislation could enhance the FTC's ability to protect privacy in the digital age, ensuring that the United States remains at the forefront of consumer protection. Conclusion: the FTC plays a pivotal role in regulating the private sector's collection and use of data in the United States. Through the enforcement of the Federal Trade Commission Act, specific laws like COPPA, and a proactive stance on emerging technologies, the FTC strives to protect consumer privacy across diverse sectors. However, the rapid pace of technological innovation and the evolving nature of data use pose ongoing challenges. Future efforts to enhance privacy protection will likely involve a combination of enforcement actions, regulatory updates, and potentially new legislation to address the complexities of the digital economy. As we navigate this evolving landscape, the FTC's adaptability and commitment to consumer protection will be crucial in safeguarding privacy in the digital age. The U.S. privacy environment, limits on private sector collection and use of financial data. The United States has a complex framework of laws and regulations governing the collection, use, and protection of financial data in the private sector. This regulatory landscape is designed to balance the benefits of financial innovation and efficiency with the need to protect consumer privacy and prevent fraud. This essay delves into the major laws and regulatory measures that shape the US privacy environment regarding financial data, providing a comprehensive overview of the mechanisms in place to safeguard consumer financial information. The Fair Credit Reporting Act of 1970, FCRA. The Fair Credit Reporting Act, FCRA, was a landmark piece of legislation enacted in 1970, laying the foundational stone for consumer rights in the context of credit reporting. It was designed to ensure the accuracy, fairness, and privacy of information in the files of consumer reporting agencies. The FCRA imposes strict guidelines on credit reporting agencies, CRAs, creditors and other entities that use credit information, requiring them to maintain the accuracy of data and providing consumers with the right to access and dispute incorrect information in their credit reports. This act also limits the circumstances under which CRAs can disclose consumer credit information, thereby playing a pivotal role in protecting consumer privacy. The Fair and Accurate Credit Transactions Act of 2003, FACTA. The Fair and Accurate Credit Transactions Act of 2003, FACTA, amended the FCRA, further enhancing consumer protections. FACTA was introduced to address the evolving challenges in the credit reporting system, including identity theft and consumer fraud. It established the consumer's right to obtain a free credit report annually from each of the major credit reporting agencies. FACTA also introduced provisions for fraud alerts, active duty alerts, and the truncation of credit card numbers on receipts to combat identity theft and fraud. The Financial Services Modernization Act of 1999, Gramm-Leach-Bliley or GLBA. The Gramm-Leach-Bliley Act, GLBA, represents a significant development in financial privacy law. It was enacted to modernize financial services by removing barriers between banking, securities, and insurance companies. However, recognizing the privacy implications of such integration, the GLBA included robust privacy and security provisions. GLBA Privacy Rule. The GLBA Privacy Rule requires financial institutions to provide customers with a privacy notice that explains their information sharing practices. Moreover, it gives consumers the right to opt out of having their personal financial information shared with non-affiliated third parties. GLBA Safeguards Rule. The GLBA Safeguards Rule mandates financial institutions to implement comprehensive security programs to protect consumers' personal information. These programs must be designed to ensure the security and confidentiality of customer records, protect against anticipated threats to the security or integrity of such information, and guard against unauthorized access to or use of customer information that could result in substantial harm or inconvenience to any customer. Exemptions under state laws. While the GLBA sets the federal baseline for privacy protection in the financial sector, states are allowed to enact more stringent laws. Some states have taken this opportunity to provide greater privacy protections for their residents, creating a patchwork of state-specific regulations that financial institutions must navigate in addition to complying with federal laws. Red Flags Rule. The Red Flags Rule, introduced by the Federal Trade Commission, FTC, under FACTA, requires financial institutions and creditors to implement programs to detect, prevent, and mitigate identity theft. The rule mandates these entities to identify and respond to patterns, practices, or specific activities, known as red flags, that could indicate identity theft. Dodd-Frank Wall Street Reform and Consumer Protection Act of 2010. The Dodd-Frank Act was enacted in response to the 2008 financial crisis, aimed at reducing risks in the financial system. Among its wide-ranging provisions, it established the Consumer Financial Protection Bureau, CFPB, which has a broad mandate to enforce consumer protection laws and regulate the offering and provision of consumer financial products or services under the federal consumer financial laws. Consumer Financial Protection Bureau, CFPB. The CFPB plays a critical role in protecting consumers in the financial sector, including the oversight of privacy practices. It ensures that consumers are treated fairly by financial institutions, enforcing federal consumer financial laws, and protecting sensitive consumer information. The CFPB also educates consumers about financial products and practices, including those related to privacy and data security. Online banking. The advent of online banking introduced new challenges and considerations for financial privacy. Regulations such as the Electronic Fund Transfer Act, EFTA, and its implementing regulation, Regulation E, provide protections for consumers using electronic means to transfer funds, including online banking transactions. These regulations ensure consumers' rights are protected in the event of unauthorized electronic fund transfers and mandate financial institutions to implement security measures to protect electronic transactions. The U.S. regulatory framework for financial data privacy is a multi-layered system designed to protect consumers while fostering innovation and efficiency in the financial services sector. Through a combination of federal and state laws, as well as regulatory measures, the U.S. aims to ensure the accuracy, fairness, and security of consumer financial information. As technology evolves and financial services become increasingly digitized, these regulations will continue to play a vital role in safeguarding consumer privacy and building trust in the financial system. Family Educational Rights and Privacy Act of 1974, FERPA. Background and purpose. FERPA was enacted in 1974 to protect the privacy of student education records. It applies to all schools that receive funds under an applicable program of the U.S. Department of Education. FERPA gives parents certain rights with respect to their children's education records. These rights transfer to the student or eligible student when they reach the age of 18 or attend a school beyond the high school level. Rights under FERPA. Access to education records. FERPA grants parents and eligible students the right to inspect and review the student's education records maintained by the school. Request to amend records. Parents and eligible students have the right to request the amendment of the student's education records that they believe are inaccurate, misleading, or otherwise in violation of the student's privacy rights under FERPA. Consent to disclosure. With certain exceptions, schools must have written permission from the parent or eligible student to release any information from a student's education record. Exceptions to consent. FERPA outlines several exceptions where schools are allowed to disclose records without consent. This includes disclosure to school officials with legitimate educational interests, other schools to which a student is transferring, and specified officials for audit or evaluation purposes. Challenges and considerations. As education systems increasingly digitize records and processes, maintaining compliance with FERPA's requirements while facilitating the necessary flow of information poses significant challenges. Schools and educational institutions must navigate these challenges to protect student privacy while enabling educational advancement. Education technology. The integration of technology into education has transformed the learning experience, offering new opportunities for personalized learning, remote education, and data-driven insights into student performance. However, this transformation also raises significant privacy concerns. Data collection and use. Education technology platforms collect vast amounts of data on students, from personal and demographic information to detailed records of interactions with educational content. This data can be invaluable for improving educational outcomes, but also poses risks to student privacy if not properly managed. Privacy concerns. Data security. Ensuring the security of student data against unauthorized access and breaches is a primary concern for educational technology providers and institutions. Consent and transparency. Parents and students may not always be fully aware of the extent of data collection or how it is used, raising issues of consent and transparency. Third-party access. Education technology often involves third-party services and applications, which may have access to student data. Ensuring these third parties adhere to privacy standards is crucial. Regulatory and ethical considerations. Compliance with FERPA. Education technology must be designed and operated in compliance with FERPA, protecting the privacy of education records while facilitating educational innovation. Student data privacy pledges. Many education technology companies have adopted student data privacy pledges, committing to safeguard student information and use it responsibly. State regulations. Several states have enacted laws specifically addressing the privacy of student data within education technology, adding another layer of regulation that companies and institutions must navigate. Conclusion. The intersection of privacy, education, and technology presents a complex landscape of legal, ethical, and practical challenges. FERPA provides a foundational legal framework for protecting student education records, while the proliferation of education technology demands ongoing attention to privacy concerns. Ensuring the security and confidentiality of student data while leveraging technology to enhance education requires a careful balance. As technology continues to evolve, so too will the strategies for protecting student privacy, necessitating continuous dialogue among educators, technology providers, policymakers, and the broader community to ensure that privacy protections keep pace with innovation. The landscape of healthcare privacy in the United States is a complex web of federal regulations designed to protect patients' personal health information, PHI, while facilitating the flow of data necessary for providing high-quality healthcare services and promoting public health. The cornerstone of this regulatory environment is the Health Insurance Portability and Accountability Act of 1996, HIPAA, which has been supplemented and updated by subsequent legislation such as the Health Information Technology for Economic and Clinical Health, HITECH Act of 2009, and the 21st Century Cures Act of 2016. Additionally, specific regulations like the Confidentiality of Substance Use Disorder, Patient Records Rule, 42 CFR Part 2, address particular areas of concern within the broader context of patient privacy. HIPAA Privacy Rule. The HIPAA Privacy Rule establishes national standards for the protection of individuals' medical records and other personal health information. It applies to 3 types of entities: health plans, healthcare clearinghouses, and healthcare providers that conduct certain transactions electronically. The rule requires appropriate safeguards to protect the privacy of personal health information and sets limits and conditions on the uses and disclosures that may be made of such information without patient authorization. It also gives patients rights over their health information, including rights to examine and obtain a copy of their health records and to request corrections. HIPAA Security Rule. Complementing the Privacy Rule, the HIPAA Security Rule sets standards for protecting the confidentiality, integrity, and availability of electronic protected health information, EPI. It requires covered entities and their business associates to implement physical, administrative, and technical safeguards to secure EPI. These safeguards include access controls, audit controls, integrity controls, and transmission security measures to ensure that EPI is not improperly altered or destroyed and is accessible only by authorized individuals. Use of online tracking technologies by HIPAA, covered entities, and business associates. The advent of online tracking technologies poses new challenges to the HIPAA framework. Covered entities and their business associates increasingly use these technologies for various purposes, including marketing, patient engagement, and operational efficiency. While HIPAA does not explicitly address online tracking, it requires that any use of EPI, including through online tracking, must comply with its privacy and security rules. This means ensuring that any collection, use, or disclosure of PHI through online tracking is adequately protected and authorized under HIPAA, Health Information Technology for Economic and Clinical Health, HITECH, Act of 2009. The HITECH Act represents a significant expansion of HIPAA rules, particularly in the areas of privacy and security. It introduced stricter penalties for HIPAA violations, expanded the scope of privacy and security protections to business associates of covered entities, and increased the legal liability for non-compliance. The Act also provided for significant investment in health information technology and incentivized the adoption of electronic health record (EHR) systems by healthcare providers. One of its key goals was to enhance the use of EHRs while ensuring the privacy and security of patient information through updated regulations and standards. The 21st Century Cures Act of 2016. The 21st Century Cures Act further advanced the regulatory framework governing health information privacy by promoting interoperability and prohibiting information blocking. The Act aimed to facilitate the exchange of health information between providers, patients, and other stakeholders to improve healthcare delivery and outcomes. It also sought to enhance innovation and research through more accessible health information while maintaining robust privacy and security protections. The Act addresses the need for modern regulations that keep pace with technological advancements and the evolving healthcare landscape. Confidentiality of Substance Use Disorder, Patient Records Rule, 42 CFR Part 2. This rule provides stringent protections for the confidentiality of substance use disorder, SUD, patient records. It prohibits the disclosure of any information identifying an individual as having or having had a SUD unless the individual provides written consent. The disclosure is allowed by a court order, or the disclosure is made to medical personnel in a medical emergency. The rule reflects the sensitive nature of SUD treatment records and the potential harm that inappropriate disclosure could cause to individuals seeking or receiving treatment. Conclusion: the U.S. healthcare privacy regulatory environment is a dynamic and evolving field shaped by legislative and technological changes. Laws and regulations like HIPAA, the HITECH Act, the 21st Century Cures Act, and the Confidentiality of Substance Use Disorder Patient Records Rule form a robust framework for protecting patient privacy. However, as technology advances and the healthcare industry becomes increasingly digital, ongoing efforts are required to ensure that regulations keep pace with innovation. The challenge lies in balancing the protection of individual privacy with the need for free flow of information to improve healthcare outcomes, a task that will continue to require careful consideration and adaptation by policymakers, healthcare providers, and other stakeholders in the healthcare ecosystem. The rapid evolution of digital technology has significantly enhanced the ability of businesses to collect, analyze, and utilize personal data for marketing purposes. While these advancements offer immense opportunities for personalized marketing and customer engagement, they also raise significant privacy concerns. The telecommunications sector, serving as the backbone for digital communication, inherently possesses vast amounts of sensitive consumer data, making it a focal point for privacy debates. The significance of regulation in protecting consumer privacy. Regulation plays a crucial role in safeguarding consumer privacy in the digital age. By setting legal boundaries and obligations for data collection and use, regulations help ensure that businesses respect consumer privacy and protect sensitive information from misuse or unauthorized access. Telemarketing and consumer protection. The Telemarketing Sales Rule, TSR, and the Telephone Consumer Protection Act, TCPA, are pivotal in regulating telemarketing practices, emphasizing consumer rights and telemarketer obligations. These regulations aim to protect consumers from unsolicited calls, with provisions like the Do Not Call registry significantly impacting telemarketing strategies by allowing consumers to opt out of telemarketing calls. Email and spam regulations. The Controlling the Assault of Non-Solicited Pornography and Marketing (CAN-SPAM) Act addresses the challenge of unsolicited commercial emails or spam. It sets requirements for commercial messaging, grants recipients the right to have emails stopped, and lays down penalties for violations. Despite its efforts, the effectiveness of the CAN-SPAM Act in significantly reducing spam is debatable, reflecting the need for continuous adaptation of regulatory frameworks to keep pace with technological advancements. Fax advertising and its regulation. The Junk Fax Prevention Act, JFPA, targets unsolicited fax advertising, requiring senders to have an existing business relationship with the recipient and to provide a clear opt-out mechanism. This legislation underscores the balance between marketing activities and consumer rights to privacy and consent. The evolving landscape of digital communications. The digital communication landscape is continuously evolving, with new platforms and technologies reshaping how businesses interact with consumers. The Wireless Domain Registry and the Telecommunications Act of 1996, with its focus on Customer Proprietary Network Information, CPNI, highlight the ongoing efforts to protect consumer privacy amidst these changes. Cable and video privacy concerns. The Cable Communications Policy Act and the Video Privacy Protection Act, VPPA, provide frameworks for protecting consumer privacy in cable services and video rental records, respectively. These acts demonstrate the legislative effort to address privacy concerns specific to entertainment and media consumption. Navigating the Road of Data Collection, DPPA, and beyond. The Driver's Privacy Protection Act, DPPA, exemplifies the challenge of protecting personal information privacy against unauthorized disclosure. emphasizing the need for stringent controls over data access and sharing. The enforcement of such privacy protections across state lines remains a complex issue, reflecting the broader challenges of data privacy in a digital and mobile world. The digital advertising ecosystem. Digital advertising relies heavily on personal data to target and personalize ads. This ecosystem's complexity necessitates a combination of self-regulation and legislative action to ensure that data collection and use practices are transparent, ethical, and respectful of consumer privacy. The emergence of data ethics. As data becomes central to marketing and telecommunications, the importance of data ethics emerges. Ethical considerations must guide the use of data, with businesses facing dilemmas about consumer surveillance, data monetization, and privacy breaches. Ethical frameworks and case studies play a crucial role in navigating these challenges, emphasizing the need for a principled approach to data use. Conclusion: the landscape of privacy in telecommunications and marketing is marked by ongoing challenges and continuous evolution. As technological advancements open new avenues for data collection and use, the interplay of legislation, regulation, and ethics becomes increasingly crucial in shaping the future of digital privacy. Balancing business interests with consumer privacy rights requires not only compliance with existing regulations, but also a proactive commitment to ethical principles and practices. The future outlook for privacy in this domain hinges on the ability of all stakeholders to adapt to the changing digital environment, ensuring that consumer privacy remains a paramount concern amidst the pursuit of innovation and engagement. Government and court access to private sector information. Right to Financial Privacy Act of 1978. The Right to Financial Privacy Act of 1978 represents